Hey everyone, today we are going to talk about partnerships. Before we continue, I want to let you know that this video discusses partnerships governed under the Partnership Act. In other words, a regular, normal partnership. We are not talking about LP, limited partnership, or LLP, limited liability partnership, which are governed under separate legislation. A regular partnership governed under the Partnership Act is where two or more individuals or companies conduct business activities. Smart people will not use this structure because there are not much benefits. There's no separate legal entity, and the partners are jointly and severally liable. Means that if anything bad happens, you can sue any one of the partners or you can sue all of them. You can cherry pick. As I mentioned before, the regular partnerships are governed under the Partnership Act. A lot of people use the word partners or partnership very loosely. They would come to me saying that, oh, they want to enter into a partnership, when in reality, what they mean is that they want to create a private limited company, okay, to carry on a business. And it's a partnership in that sense. That's what they mean. So it is very important to know this distinction. Partnerships are governed under the Partnership Act. So the relations and obligations between the partners are determined by a partnership agreement, which the partners have to enter into. The relationship and obligations between the partners are set out in a partnership agreement. The partnership agreement would usually include the rights, the responsibilities, and liabilities of the partners towards the firm, and also determine the terms of the partnership agreement. In the absence of a partnership agreement, profits are divided among the partners equally, and the partners own the assets collectively. That means together. There are many disadvantages of a partnership. As I mentioned before, the partners are jointly and severally liable. That means you can sue anyone or you can sue one of them. So, I once sued a partnership. In fact, I was very happy when I did a search on the business and found out that it's actually a partnership, because under the rules of court, if you are suing a partnership, you don't have to serve the writ of summons, the court documents. You can click the link below. You don't have to serve the writ of summons on each partner. Serving on one partner is as good as serving on the firm. Also, I was also very happy. Me and my client were very happy because two of the partners own landed property in their own names, which means that so when they lost a case, they had to pay. Otherwise, we could take out a writ of seizure and sale to sell their landed property, which is cost millions, to pay the damages. What are the other disadvantages of a partnership? Well, each partner has the power to bind the firm. So, because every partner is deemed to be an agent of the firm, and is entitled to bind his other partners through his own acts. For example, if one partner signs a contract, okay, on behalf of the partnership, all the partners are bound by this contract, even if they are not aware of the nature or the terms of this contract. Also, any instrument relating to the business of the firm and done or executed in the firm name or in any other manner showing an intention to bind the firm by any person authorized, whether a partner or not, is binding on the firm and all the partners. So if a partner signs a guarantee, okay, it will bind all the other partners who will be jointly and severally liable under the guarantee. As I mentioned before, every partner is liable jointly with the other partners for all debts and obligations, even after his death. So if a partner of a firm dies, his estate is also severally liable for the debt. Severally means chopped up. his share of the debt. On the topic of joint and several liability, what this means is that if you sue a firm consisting of 5 partners and you win the lawsuit, you can cherry pick who you want to seize assets from. So if the judgment sum is, for example, 5 million, and you know these 2 partners, okay, have assets more than 5 million, you can take out a writ of seizure and sale or a garnishee order. You can click on the link below to find out what is a writ of seizure and sale and garnishee order from the 2 richest partners. Essentially, you can cherry pick. So, another disadvantage is that, well, all the partners are entitled to share equally in the profits of the business, but if the partnership, the firm, loses money, they all have to contribute equally towards the losses, whether capital or otherwise, sustained by the firm, okay, unless the partnership agreement states otherwise. Also, no partner shall be entitled to remuneration for acting in the partnership business, because all partners are deemed to be working together for the benefit of the firm. Therefore, they are entitled to share equally in the profits. So when you share equally in the profits, you're not entitled to additional remuneration. The Partnership Act also has a specific provision that a partner has a duty not to compete with the partnership, and he has to pay over to the firm all profits made by him if he conducts a competing business. So thanks for watching this video. Stay tuned for the other videos on corporate structures in Singapore.